SJC-12164, Great Divide Insurance Company v. Lexington Insurance Company.
Mr. Doherty, good morning.
Good morning, Your Honors. May it please the Court, my name is Adam Doherty. I'm here today with my partner, Tom Elcock, and we represent Great Divide Insurance Company. We're here on a certified question from Judge Stearns at the United States District Court for the District of Massachusetts. The question involves the priority of coverage between an auto liability policy that Great Divide issued to its insured Easy Disposal and an umbrella liability policy that Lexington issued to its own separate insured, Capital Waste Services. The reason that the two policies are at issue is that Easy Disposal's employee was operating a garbage truck insured under the Lexington policy at the time of the underlying accident. This court has never considered a priority of coverage dispute concerning an auto liability, excuse me, an auto liability policy and an umbrella liability policy. But we submit that this court's decision in Mission versus, excuse me, versus U.S. Fire, which has been the seminal case on priority of coverage disputes for nearly 30 years, squarely controls.
Do you think Mission Insurance says something other than that you consider the entire insurance policy as a whole?
No, I think it's that simple, Your Honor. I think that the Mission case requires that when you're considering a priority of coverage dispute, the first step is that you look at each policy separately. And you have to determine what the relationship is between each insurer and its insured. So in this case, there's no dispute that the Lexington policy is a first layer excess policy. We don't dispute that. But when you apply the principles set forth in Mission to the clear and unambiguous language in the Great Divide policy, it's clear that the Great Divide policy also applies on a first layer excess basis in this case.
But what Lexington is saying is if you take a look at the policy as a whole, both policies as a whole, and that Lexington is more of an umbrella policy. There's no bodily injury, there's no right to defend, there's no requirement of underlying insurance. And if you take the two policies as a whole, that Lexington is more of an umbrella policy than Divide.
That's the mistake that Lexington makes, is you don't look at the two policies as a whole. You look at each individual policy separately as a whole.
So you don't compare the policies?
Not when you're determining the relationship between the insured and its insurer.
Well, if you're trying to determine the level of the layer of risk and whether it's the same, don't you have to look at both policies to determine that?
Yes, but you determine where each policy applies by looking at that policy individually.
Let me ask you, do you think Mission sets forth a specific rule of construction just for insurance policies, or are we to take the rules of construction that apply to all contracts?
No, as the Mission courts stated, it's simply an outgrowth of the principles that apply to all contracts.
So it's not a special rule of construction?
No,
Okay.
It's not, Your Honor. And that's because, like all contracts, insurance policies, the courts presume that the words used by the parties to a contract and the parties to an insurance policy were used for a reason. And in this case, if you look at the Great Divide policy, it is not a primary policy with an excess other insurance provision. It's a policy that provides two separate coverages. With respect to autos that the insured owns, it is primary, period.
You would agree, wouldn't you, that the insurance treatises would say that it was exactly that. It was a primary policy with an excess it's not a true excess policy. So, I mean, the treatises categorize different kinds of policies, right? And under the treatises, yours does not fall under the same category as the Lexington policy.
But under Mission, Your Honor, it doesn't have to be the same type of policy. And Mission and its progeny, the courts have said, it doesn't matter, the nature of the policy doesn't matter, the type of the policy doesn't matter. All that matters is the actual language of the policy. And when you look at the actual language of the Great Divide policy, it clearly and unambiguously states that with respect to autos that the insured does not own, it is only excess in that case.
But what about the fact that Great Divide is the primary carrier? And, I mean, the relationship of Great Divide to the insurer is different from the relationship to Lexington. Lexington is a true excess carrier, as they say. And Great Divide is a primary, has primary coverage. So what do we do about that?
It has primary coverage with respect to owned autos, but it states that with respect to liability arising out of the operation, maintenance, or use of a non-owned auto, it is an excess policy. And in this case, the commerce policy issued to Capital Waste Services, Lexington's insured, is providing primary coverage. But you have to look at and the mistake that the treatises make is that the treatises rely on the majority rule. And the majority rule is based on things other than the actual language of the policies at issue. So the majority rule does not employ the rules of construction that are required by the mission court. You have to look at the actual language of the policy. And even if the actual language leads to a result that may not have been intended by the parties to the contract, it still has to be effectuated in accordance with its plain and ordinary meaning. So the problem with the majority rule is perfectly highlighted by the decision in Lamar's Mutual versus Farman City, which is located at 494 Northwest 2nd, 216. And this is important because this is the case that Lexington principally relies on. Lexington devotes pages of its brief to this case and leads its discussion of the foreign case law with this case. But this case shows that the majority rule is not persuasive authority in Massachusetts. In that case, Lamar's Mutual, the Iowa Supreme Court begins by looking at the auto liability policy, which similarly had a non-owned auto provision in it. And the court says, well, we agree that a plain reading of this language means that the auto liability policy is an excess policy. It applies on a first layer excess basis. Under mission, that's game over. The analysis ends because mission says you effectuate a policy as it is written. The nature of the policy doesn't matter. The type of the policy doesn't matter. The scope of coverage under the policy doesn't matter. You effectuate it as it is written. So the Lamar's Mutual Court found that the auto liability policy in that case, which is substantively identical to the Great Divide policy, was an excess policy. But then it goes on. It doesn't end the analysis as mission would have required. It goes on to consider things like the scope of the policy, the intent of the parties to each policy. Those factors are irrelevant under mission. And then the Iowa Supreme Court makes it clear that it just dispensed entirely with rules of construction. On page 219, and I'll quote this, it says, quote, "We believe the resolution of the question of priority and payment must come, as the majority rule indicates, from a common sense look at the basic function each policy was intended to serve. Competing other insurance clauses in the Farman City and Lamar's Mutual policies, which normally would invoke contract construction rules, must yield to a finding of the insurance policy's main functions." That is directly contrary to Massachusetts law. Okay? It is a bedrock principle of Massachusetts law, both contract and insurance coverage law, that you effectuate the actual language of the policies.
Well, how
because they mean
about
something.
going to Lamar's? What about this premium factor? And let's talk about what the insurance policies are doing, not the coverage limits, but what they're doing. Isn't Lexington covering a greater risk, and Great Divide has a lesser risk if you look on a macro level, not a micro level of comparison?
Not with respect to non-owned autos, Your Honor. This all comes.
I understand.
Yeah.
I appreciate that, and you made the point well. Yeah. But as a general matter, isn't Lexington insure a greater risk?
There are other circumstances under which the Great Divide policy would attach on $1. But these cases have to be determined on the facts of the case, not on hypotheticals. And premium is also completely irrelevant because whether you pay $1 or $1 million for a policy, the coverage under that policy is dictated by the four corners of the contract and by the language of the contract. So any premium-based argument is completely inconsistent with Massachusetts law. And that's where the majority rule cases fail. There are a minority of courts that have considered this issue and properly looked simply at the language of the policies. And when those courts have applied rules of construction consistent with mission, they have found that even though the auto liability policy provides primary coverage in some circumstances, with respect to a non-owned auto, it provides only excess coverage. And they've effectuated that language as it is written.
Does it matter that the two policies in Mission were both true excess policies? I mean, you're laying your whole case on what you say is an interpretation of Mission, but does Mission really govern this situation where we don't have two mutually repugnant policy provisions here?
Well, yes, mission does apply because it's the principle set forth in mission as applied to this case that leads to a result that Great Divide's requesting.
And that is?
That you have to look at you have to effectuate the agreement between Great Divide and its insured Easy Disposal. Great Divide never agreed to provide primary coverage on a non-owned auto. When it issued its policy to Easy Disposal, it said, look, we're going to provide primary coverage if your liability arises out of an owned vehicle. But if your employee is driving a non-owned vehicle at the time of the accident, we are only going to provide excess coverage. So the other insurance provisions are mutually repugnant because under the particular facts of this case, they apply at the exact same level. They both apply above the commerce policy. And because of that, you then have to look at the other insurance provisions to determine whether they can be reconciled or whether they're mutually repugnant. And in this case, the parties agree that the other insurance provisions are in fact mutually repugnant.
If I can turn you from there, let's assume that they are. What do we do with the pro rata share? If the Lexington policy had a provision that said we'll split it 50-50, and your provision has it that they'll bear only their proportion of the limits, what do we do? And why should we honor the pro rata if we declare it mutually repugnant?
Right. So in this case, if Lexington did address contribution in its policy
It's silent on it.
in a different way, then those clauses would be mutually repugnant, and the default rule under mission would apply, which is 50-50.
And why should we not apply that mutually repugnant, a 50-50 rule? Because the nature of what, I mean, if you think about it, a true excess policy is going to generally be larger than your policy, which has the same limits as primary, and therefore you're always going to do better under your pro rata theme with a true excess policy than you otherwise would. And does that defeat your argument that you are truly an excess policy? Because it means you want to be treated like an excess policy, but you don't have the limits of an excess policy.
Well, no, Your Honor, because under mission says that in the absence of language controlling the issue, the default rule applies. But we have language in the Great Divide policy. And what mission in cases like the USF&G case where this court reconciled an excess clause and a super escape clause show is that this court works very hard to reconcile competing policies in a way to effectuate the policies to the greatest extent possible. And you can effectuate both policies. You can effectuate the language of both policies by doing a pro rata by limits allocation. Because we're not asking Lexington, to do anything it didn't already agree to do. It agreed to provide $10 million of limits in excess of the underlying commerce policy. Great Divide told its insured that if this policy form applies with any other policy form, whether it be primary or excess, we'll pay our share, and our share is the pro rata by limits. So the mission says you have to, if you can effectuate that language, without leaving the insured with no coverage, you have to effectuate that language. And Lexington says you can't apply it because our policy is silent on it. But if that were the case, then the appeals court in Maroney wouldn't have applied the other insurance provision because only one policy had it. The court said, well, no, that doesn't matter. We have to effectuate this language if there's a way to do that, and we will effectuate it by giving the proper meaning to those words.
All right, thank you.
All right, thank you, Your Honor.
Ms. Hartman, good morning.
Good morning. May it please the court. Good morning. Kim Hartman on behalf of Lexington Insurance Companies. This is a case of first impression in this state. The issue is whether Massachusetts will adopt the overwhelming, nearly universal rule that true excess policies, insurance contained in excess, umbrella, and catastrophe policies ensure a distinct and higher layer of risk and provide insurance over and above any primary policies, including a primary auto policy, which
Okay.
contains an excess clause.
Right, but to do that, do we have to overturn Mission?
Your Honor, no, we do not need to overturn Mission. Mission provides the framework for deciding the threshold question as to whether or not these two types of insurance policies ensure the same layer of risk.
Is
And
it
I
a
think
type of insurance policy or is it a particular insurance policy?
it is a type of insurance policy. Lexington is not advocating that there be an ad hoc, examination every time a court, an appellate court, is called to ask or to review priority of coverage. We're really asking the court to determine whether true excess policies are fundamentally different in nature than a primary policy, even
So
those
you
with
don't look at a
excess clauses.
specific policy to see whether that specific policy, how it treats particular risks?
Certainly you do. I mean, you do look and see, that's how you
And
determine.
here, there really is a separate way of treating non-owned automobiles. The risk is treated separately. It is not done as a primary policy.
Certainly, and when you look at a primary auto policy, and almost every jurisdiction that has looked at this same exact issue, you see that a primary auto policy with an excess clause only provides excess insurance in one limited circumstance. The premium that you pay and the limits that you get in a primary auto policy, go into in factoring in consideration that really is truly a primary auto policy.
But even if it is, so what? Why don't we just look at the policy itself and see how it works?
Well, that's not what, well, you do. I'm sorry. Yes, you do, Your Honor. You do need to look at the policies, at the primary policy with an excess clause, and see the type of insurance provided and the scope of risks insured, and compare that with a true excess policy, an umbrella or catastrophe policy, and the scope of risks that type of policy insures.
But with respect just to the category in question here, which is non-owned automobiles, aren't they the same?
No, Your Honor, because what Mission says is not, the question in Mission is not whether you have two policies that provide excess insurance. In fact, in Mission, you had two true excess policies. What Mission says is you need to examine whether the two insurers provide excess insurance, quote, to the same degree, end quote. And when you compare the excess clause to the true nature of the excess insurance contained in Lexington's policy, they do not provide the same type of excess insurance to the same degree.
Ms. Hartman, what would Great Divide have had to do to have their policy interpreted as they say they intended? What would they have had to do in order to get the pro rata?
For the pro rata by limits argument that Great Divide is making?
Right.
Is that the question? So in order to get into a question as to allocation, then Great Divide needs to establish that its insurance policy ensures the same interest and the same risk on the same layer of coverage. And in that case, which we argue is not the case here, then the two other insurance clauses would be considered mutually repugnant. But in that circumstance, Mission is also instructive and states that the default rule and the most equitable rule is to require each insurer to provide coverage on an equal basis up to the limits of the lower policy and thereafter up to the limits of the policy with more coverage. The only exception is if there is controlling language stating otherwise. And so here what Great Divide is essentially asking this court to do is to read out of that opinion, out of this court's opinion, the word controlling, because here Lexington has not agreed to such an inequitable type of allocation. And just recently, last year in 2006, in the ICSOP case, which is referenced in Lexington's brief, this court specifically discussed how the more equitable method for allocation under such circumstance is by equal shares. But I do want to go back to...
Before you go back,
Sure.
would it matter, following up on Justice Budd's question, if Great Divide had issued two policies to EZ? We're going to issue Policy 1, which is a primary policy, which refers to owned autos, and we're going to issue a second policy, which we will call a true excess policy, which applies to non-owned autos. And each is $1 million. Does that second policy then become a true excess policy?
That second policy, we're assuming then that the second policy, that the Great Divide policy is scheduled underlying insurance to the second policy. And in that circumstance, you are correct, Your Honor, that the second policy would be on this, would ensure the same layer of risk as the Lexington policy.
So in your view, the fact that it's all encompassed within a single policy makes all the difference?
I don't think it makes a difference whether or not there exists another layer of insurance over Great Divide's policy. When you look at Mission, which I think really provides the framework here, in Mission, they looked at two true excess policies and whether they insured the same risk, and they both were over two scheduled underlying policies, a primary policy which insured the vehicle and a primary policy which insured the owner. So Great Divide's policy is really analogous to what to the underlying primary policy insuring the driver in the Mission case. And so what I think it's important to look at, what the other insurance clause in Great Divide's policy was meant to do. And Great Divide has received the benefit of its other insurance clause because it provided primary insurance and the Commerce policy provided primary insurance. But because Great Divide's policy had an other insurance clause making it excess for non-owned vehicles, Commerce provides the first layer of primary coverage, but then Great Divide provides the second layer of primary coverage. And so it's received the benefit.
Let's look at this on a clean slate for a moment and forget the majority view. I think what Great Divide is saying is that you don't necessarily look at same risk and same coverage as one and the same. I think what they're saying is you take a look at the language of each of the insurance policies and you see that they both contain excess coverage. And it's as simple as that. And indeed, Lexington could have put a provision in its policy that it would be in excess of any auto policy with an ISO.
Well, certainly, if you look at Lexington's policy, and I agree, Your Honor, that you do need to look at both policies and what's insured under both policies, but again, the coverage for non-owned vehicles is very different, fundamentally different in nature than the excess insurance provided in Lexington's policy. And you do need to go back and you need to read the policies. And the only place in the Great Divide policy where you will find that there is any coverage on an excess basis is for non-owned vehicles. But when you go and you look at the Lexington policy, you see it in the insuring agreement. You see it in the requirement that a retained limit be reached. You see it in the limits of insurance where scheduled underlying insurance and other insurance must be exhausted. You see it in the declarations. You also see it in the other insurance clause. You see that in the Lexington policy there is no primary defense obligation. You look at the premiums and you look at the premium to limits ratio. You see that in Great Divide, it's, I believe the estimated premium for that policy, which covered one risk, an auto-related risk, was approximately $96,000 for $1 million in coverage. You compare, that's a 1 to a little less than 1 to 10 ratio. You look at the premiums to limits ratio on the Lexington policy, and it's a 1 to 84 ratio. The estimated premium for the Lexington policy is $120,000. It covers not only autos, but employer's liability as well as general liability, and it provides $10 million in limits. That's a 1 to 84 ratio, and it really underscores the fundamental difference between the two policies in that the Lexington policy is a true excess policy that does not come into play until all other primary policies, including those with excess clauses, exhaust. And there's a financial and socioeconomic benefit to understanding and recognizing the fundamental difference between excess policies and enabling insurance carriers to provide these very large amounts of coverage for relatively low premiums. It's because they're only called upon to provide coverage after the exhaustion of all other types of primary insurance or general excess clauses. And this court, other than Mission, this court in All America and in other cases has really looked at what is the layer of risk that each insurance policy covers.
And how do you decide that? How do you decide what is the layer of risk that each policy covers?
You look at the entire scope of the individual insurance contracts. What Mission says is you look at the language of the policies as a whole and the scope of risks insured.
But you're not comparing and contrasting between the two policies until you've examined each and every one of them separately, right?
Correct, Your Honor.
That's why I'm a little bit confused, is if we take kind of a holistic look at the three policies, aren't the insured and the insurance company bound by what they say in their individual policy?
Certainly you're correct, Your Honor, in the insuring agreement governs the relationship between the insurer and the insured. Yes, sure.
But are you telling us to take a look at that language, which governs the relationship, but then take a holistic look at the three policies and then figure it out?
No, Your Honor, you look individually, and this is a point that I do agree on with Great Divide, is that you look at the insurer-insured relationship as for each policy, and then you compare whether it's the same, whether the insurance provided is excess insurance to the same degree. So in our case, Great Divide's policy is really on the same layer of primary insurance as the Commerce policy. Now, because
Why
of
do you
its
say that? Because I understand it as to the autos that are owned, but as to the non-owned autos, why is that the same layer? That's where you lose me each time.
they both provide primary insurance.
So I understand they provide primary insurance as to the owned autos. They don't provide primary insurance as to the non-owned autos.
Correct, which is why, although they both sit on the same, although they're both essentially primary policies, Commerce comes first. There's no dispute that Commerce provides the first layer of primary insurance. But the second layer of primary insurance...
Only as to owned autos, though.
Correct, Your Honor. But then for non-owned autos, then Great Divide provides this you can characterize it either as the second layer of primary insurance or
Why would
first
you
layer.
ever say it's primary insurance, though?
I guess the distinction, you could, Your Honor, call it a first layer of excess insurance.
Or just excess insurance?
Excess insurance provided by an excess clause, although it's still fundamentally different than the excess insurance provided by Lexington, which is what almost every other jurisdiction has
Have
considered.
a hybrid, an excess hybrid, because it sounds like you're suggesting a lesser category of excess insurance. Does our law recognize such a thing?
There's certainly been cases and secondary authorities which have made that distinction between insurance provided under an excess clause and true excess insurance. And in fact, going back to Mission, the question there was whether two excess insurers provided excess insurance to the same degree. So yes, you are correct. You can recognize, and Lexington is asking this court to recognize that, insurance provided under an excess clause here is inferior and must exhaust before the true excess insurance of Lexington's policy is called to provide coverage.
I hate to take something so complicated and make it so simple, but doesn't it depend on whether you look at it on a micro level and you look at the two excess clauses and compare them, or whether you look on a macro level of what exactly is Great Divide insuring and what exactly is Lexington?
I do believe that you have to look on a macro level, and that is what Mission requires. And when you follow Mission's instruction and the framework provided by Mission, then it would lead to the majority rule.
Okay, I'm going to ask you to imagine for one moment the possibility that you may not prevail on this, which is not a prediction, just a hypothetical.
Sure.
And then if that were to happen, should we apply the pro rata formula in the Great Divide policy, or should we do it 50-50?
Your Honor, the law here would guide for a 50-50 allocation under such circumstances, and Mission rejected the notion that anything other than equal shares would be the preferred method. That is the default rule.
Why is that when their policy specifically speaks of an allocation different than that?
Because their policy is not controlling over Lexington's policy. And in Mission, and I believe in the ICSOP case, this court, determined that, it's unsure how, it's, difficult to speculate as to why certain policies charge certain premiums for certain limits. But what is known is that for the risk covered, the insureds paid and compensated the insurance carriers. And so it really parlays into not just an equitable principle, but also a risk-sharing principle.
To your view that if they are truly mutually repugnant, which you say they're not, then it should be an equal allocation of the risk.
Correct, Your Honor.
Right, thank you.
Thank you.